Hello and welcome to the first episode of Wise Voice, which is going to be a series of podcasts where we are going to meet different experts of different fields and we'll try to discuss those certain topics which are, seldom touched upon the internet because of, a few reasons. Well, for now, in the first episode, we are going to discuss about the Constitution in a different perspective, in a different way, not about the interpretation of the Constitution of India. And for this discussion, we have today with us Advocate Ravindra Vikram, who is a lawyer practicing in Delhi. First of all, welcome and thank you very much for joining this podcast, Army.
Thank you for having me here.
Yeah. So let me just do you a quick brief about what this podcast is going to be about. The whole focus of this podcast would be more towards the judiciary and the judicial structure, powers. So first of all, I'd like you to tell public about what really the Constitution of India is based upon and who is handling all the laws and everything in India. Is it the parliament, judiciary or something else?
So, the basis of all the law comes from the Constitution. And the Indian Constitution is one of the largest constitution that has taken from, in that time, whatever was the best philosophies of law and sublimed them into a very beautiful document, which we have inherited from framers of the Constitution. They took few years to come up with a decently crafted document.
So first question is the most common question that we common people discuss in our day-to-day life when we meet others for a cup of tea. And that would be, why does courts take so much time to finish one procedure of a single, case? If it is a criminal trial, it sometimes takes more than 10, 12 years to finish. So why is it so?
In India, judiciary is overburdened with lots of cases. It is right that a lot of cases take longer duration compared to other places, other countries, and also sometimes the litigants lose patience once it's taking decades or more than decades, and it costs them a huge period in their time running around courts. But at the same time, we have to understand that again, we are a developing nation, and most of the infrastructure we had inherited from the British. And after 1947, our priorities have been more on physical infrastructure development than on health education. We have still not come down to a level where we are focused in having good infrastructure in various parts of the nation. So maybe in Delhi, you will find a robust judicial system. But other places, we are still working from old courtrooms and not having enough courtrooms, not having enough employees, not having enough judges, fund crunch. So till the time that is evolved and we have a good infrastructure, at the same time, sometimes delay also happens because of the investigating agencies. So that also delays the procedure of getting justice.
Yes, but if we see certain cases, there is no doubt that judiciary is the one of the most important institutions of India to run the constitution well. But suppose if we take the example of any famous case, suppose Nirbhaya case is there, where the charge sheet and everything was done in, I guess, some 5 or 6 months only. After that, the conviction was done by the first court in under a year only. How much can you justify this fact that this whole case took more than a decade or almost a decade?
You answered my question. In any jurisdiction, after you're convicted, you are in jail, right? And after that, you have a right to appeal. So what took time were appeals. And what happens, you go to a higher court, then you go to Supreme Court. It's just that they also have a place to appeal. And higher courts look at if there's something wrong in the judgment pronounced by the lower court. In that case, those verdicts can be reversed or some relaxation could be given. So nothing like that happened in the Nirbhaya case. But as accused, they also have a right to appeal, and that's what they got.
Is it not really concerning for the even citizens of India and the judicial officers, for the fraternity of judiciary, that it creates a certain opportunity for say accused to manipulate the evidences and many more?
So once you've convicted, it's irrelevant if you can temper the evidence or not, but your conviction is done. So what higher courts will look into if there has been any procedural lapse, any legal lapse. So if you have been wrongfully convicted, so if those things are there, then they might consider your plea. Otherwise, they would upheld the conviction of the lower court. So
We don't know about the delay. I mean, it is definitely, you know about the delays, but 10 years, yeah, more than 10 years is it's really a big time.
But the verdict came much before 10 years. It was only appeals which were mostly rejected. So if they were convicted, that part of the process is over, right? So where's the delay? There's no delay in that case. But for example, if conviction happens after 7 years or 10 years or 5 years or 6 years, then of course is the right case for delay. But you cannot take away right of anybody to appeal.
It might be a global truth that the appeal system takes time. Although we are very notorious to, our country especially, to take much more time to, finish a trial as compared to other nations, especially Western countries. But still, we see if suppose there is an other example, some people who were convicted in the Akshardham 2002 case, they were found non-guilty after 6 years of time spent in jail. Even after that, they were not compensated with anything for the time that was totally wasted in their life of precious 6 years in jail.
Right.
What do you say? What would you say about that?
Right. So in India, compensation system has not evolved, right? So that's for legislature to look into, and it's more of a policy issue than issue for the judiciary. And I think the government should come up. What is the wrongful incineration? Then it's right for the government to compensate, but also look at burden on the courts. For example, Supreme Court of USA hears 84, almost around 84 matters in a year. In our Supreme Court is People's Court. One court hears more than 100 matters in a day. So if they're hearing that much of a matter, our speed of providing justice is quite good. But at the same time, we have huge population, too much of litigation, and at the same time, we are still struggling with infrastructure, and it's not just for judiciary, it's for everything.
Yeah. We can see that we are not significantly changing our infrastructure, especially when it comes to these, judicial institutions, whereas we have rapidly grown in our population. That can be a reason. Let's just jump directly to the next topic about the powers. Ideally, it is definitely good to be, in an equivalent power when it comes to the three pillars of, constitution. We always see, one another subjugating or trying to subjugate the other institute, the other, part to be the supreme leader, the supreme power of India. Is it so?
I don't think so. I'll tell you reasons why. So, legislation have been given sole power to legislate new laws, to make new laws, right? So, whenever you are doing something new, you're creating something new, either according to the needs of the society or through in thin air, there would be times you will step over your boundaries. You would not be able to understand where is the fine line. So that's when Supreme Court comes in, and if any act of executive is beyond those lines which breach fundamental rights or which breach basic structure, then Supreme Court has rights to make that part which breaches either fundamental rights or basic structure of the Constitution, to make those parts inoperative.
I'd like to enlighten this basic structure doctrine which you mentioned here in the answer, which is basically a set of principles of the Constitution of India, written in the Constitution of India, which cannot be amended or curtailed in any way by the parliament or judiciary, by anyone in the nation. But still, when we see after the Keshwanand Bharati case as well, when the basic structure doctrine was introduced, which comes against the Article 368 of Constitution, which provides Parliament all the rights to curtail or amend any law, any article written in the Constitution of India. But what we see after the introduction of basic structure doctrine, it comes 42nd Amendment, and the 9th schedule is also there, where Parliament has always tried to amend something in such a way, to amend a bill in such a way that they could, surpass the limitations of basic structure doctrine, even to curtail, remove, or somehow amend the fundamental rights of India as well.
Right. So, what we are talking about are one of the most difficult times which Indian democracy has passed through, and which period is referred to as when India was under emergency rule. Right. But if you look at years after it, at Amendment 44, 45, 46, and what we see, whatever was beyond or in breach of basic structure or in breach of fundamental rights was done away with, and the originals where it was deemed required was restored. The initial
Is it true that a judiciary can only intervene when someone challenges those amendments, those bill which Parliament is amending or introducing? After that only.
that is the usual way. It's because what happens when something is overdone or something is overreaches upon somebody, right? That person would just stand up and will go to the court.
So if we take the example of those litigations which have entered the judiciary, the Supreme Court after the introduction of some certain bill, we see that out of 105 amendments that have took till now, 16 were challenged in the Supreme Court regarding that this is against the morals of the basic structure doctrine. 9 of them were totally given a clean chit. They were allowed to be amended, and the other 7 were somehow abolished by the judiciary. So why is it so that even if the fundamental rights are getting amended, the judiciary only takes somewhere a part in abolishing it and not in every term?
Right, it's a very subjective question like the law is, but let me try to answer it. So, making an appeal or going to court with some grounds that these laws or this provision is in violation of fundamental right is your fundamental right. Right? You can go take up any issue and go to the court. Then it is for court to consider, to test it with seasoned principles of basic structure of all doctrines, and then come to an understanding that this objection which you're having is really in breach of fundamental rights or basic structures, or is not in breach. Sometimes, or most of the times, these are just policy matters with litigants raise up, and Supreme Court cannot interfere into a policy matter.
Okay, if we as a citizen take some concern about running of this constitution, I think we will have to keep a certain level of faith to believe that yes, we have the basic structure doctrine. Now I'd like to focus upon something else, especially to the public, that we had 7 fundamental rights, if I'm not wrong. So we have already seen that one very important fundamental right to property, has totally been removed from the fundamental rights list. Do we still believe that yes, the basic structure doctrine and these amendments which are going right now in the parliament are not something to be concerned when it comes to the constitution, the framework?
I think so. This question calls for a longer discussion, but that right per se has not been removed totally from the constitution. That right has been reinstituted under 300A in 1978 as you have right to property. But again, it's not a fundamental right, because now government can take over your land and with giving you a due compensation. But I think so, once we have more time to deliberate on that phase or the era of 70s or 70 to 80s, where a lot of changes happened, and as constitutional democracy, we tested a lot of our principles. I think so. You should have a session specifically on it sometime.
Okay, let's just skip this for now. Let's talk about 9th schedule,
Right.
which I believe it is very intimidating for me only.
Right.
So I'd like to know what really is 9th schedule and why is it so concerning for the citizens of India, and why What do you think about the ninth schedule?
So if some provision is placed under the ninth schedule, the courts do not have right for judicial review, right? So that is why everybody gets concerned when something is placed under ninth schedule, or government moves the provision from anywhere to ninth schedule, and it gets everybody worried that once courts have no power to review it, how would if there's a breach happening, how can they take this up and how can they resolve the issue? But in a case in 2007, Iyer Kolo versus Kelo versus State of Tamil Nadu, court has upheld that in the case that law or that provision is beyond the basic structure of the Constitution, then Supreme Court can go for judicial review. So Parliament has supreme power to place any law under it, but as everybody says, we are a constitutional democracy. So constitutional takes over everything else. So if that law is in breach of the principles or basic tenets of this constitution, which can roughly be called as basic structure, then Supreme Court can can take it up under judicial review.
Okay, I don't know if I look at it, the Article 368 and the amendment of ninth schedule as something which is really crucial to be well revised. Because if we see, it was not really important to introduce ninth schedule only to safeguard some land reforms. They could have just specifically gone through those land reforms to save themselves, to remove them from challenging of any person in the Supreme Court or any judicial judgment. Was it really important to introduce the whole ninth schedule, which clearly states that Parliament has all the powers to amend, curtail, or change any law, any given fundamental right from the book of Constitution, and Supreme Court has no right to intervene in the bill, the amendment that has been put into the ninth schedule.
So what? Supreme Court has no right in the bills. That's out and clear, right? So bills are complete discretion of the Parliament.
It cannot even challenge.
Right. So once it becomes an act, right, and that act is in violation of fundamental rights or of basic structure, Supreme Court can take it up. It can review it. The framers of our Constitution were worried about these overreaches, and they evolved a system which had very fair checks and balances. So we are not a nation where democracy has supremacy over everything. We are not a nation where theory of law has supremacy over everything. So it's balance of both. If democracy wants to overpower laws or the rights of people, then they will be overdone by the judiciary. If judiciary wants to trample upon the rights of the Parliament, then parliaments can ensure that doesn't happen. So it's kind of a very balanced framework given by our framers.
Okay, I don't know how much people will agree with this logic or not, but still. So this next question is not mine, but it is oftenly raised in the public. If the power of Supreme Court is getting anyway compromised, for example, the NJAC and the collegial system, the Supreme Court makes sure that they abolish and curtail or do some changes in that particular bill only, and it pays somewhere less attention to others which are not really related to the powers of Supreme Court.
So I would again disagree. So at the end of the day, everybody is a citizen, right? So first it has to stand up for itself. If it is not standing up for itself, how do you expect it to stand for others? And there are innumerable judgments, innumerable instances when Supreme Court has taken as hard a step as possible to restrain governments overreaching or trampling upon the rights of general public.
I mean, I really believe that this is somewhere a trial of subjugation from the Parliament to keep judiciary at a
As I've said, Parliament being elected body and having will of the people, so to say, for 5 years, would always want to trample upon rights which curtail its limitless freedom, so to say. But you have to understand that this country runs through a constitution, right? So if that freedom or that power which has been bestowed on it by the constitution makes it to make a law which overreaches other organization or population, then Supreme Court very well has a right to stand up and to take a stand and to put that law down.
If we take a hypothetical equation, so we'll leave the hypothetical equation after the basic structure doctrine introduction. The 42nd Amendment Act came, where Parliament said that they keep all the rights to themselves to curtail or amend any right, including the fundamental right as well. And they passed a bill only to just to overpower the basic structure, which was not challenged until the Minerva Mills case.
So it was challenged, and Minerva Mill came,
And the case came in front of judiciary.
Yeah, that's how the process works. It's not a debate which is a live debate happening. So somebody passes a law by their own words, another person replies and puts down that law. It's not a war. So it's a constant process of having evolution of our own understanding and coming to a better conclusion.
Let's take a different case, a little different from this. Judiciary recently made its decision about the administrative powers of Delhi should be under the government of Delhi only, the state government of Delhi.
Right.
And after some time, the Parliament introduced a whole new bill that is called the Delhi Services Bill, in which it introduced that the administrative powers of the UT of Delhi would be under the lieutenant governor, that is the union government only. So what happened here is the Parliament totally cancelled the decision of judiciary, which should be respected because it is also the the one of the pillars of constitution.
So what happens in a case in judiciary? It looks at specific things. Judiciary will take a decision on certain issue, but if it is in regard to policy, the Parliament has a supreme right over policy issue.
Right. Yeah, that is sort of a, I don't know if it is a diplomatic answer, but definitely something a lawyer would answer it because
it's not diplomatic answer. So
I think
Supreme Court itself has said number of times that if it is a policy issue, we will not intervene. For example, you are serving in an army, right? And you feel it's being posted at a very strong location. You might feel it's in violation of your personal rights and liberty, right? Because you don't want to be posted there, and there could be circumstances where somebody is not well or something is happening in a family. And you go to High Court, then you go to Supreme Court, right? For if you go. The court cannot dictate that specific armed force or organization to function, because if courts starts doing it, they will have no other jobs than to micromanage the country. So that part is done by administration. And then there are parts of parts and responsibility for legislators to be done. And there are some specific parts which Supreme Court has to ensure as checks and balance. If one of these organs overreaches, one of these pillars overreaches on other's right or on side or on the third pillar, then they have to do away with it. They cannot get into all policy matters for that matter.
Okay. I don't know why does it. People never had any complaints with the decisions of Supreme Court or Supreme Court being getting intervened into some new bill or something. They have always this certain sort of faith, belief in the judiciary. If we do a random survey, most of people would be in the favor of judiciary only. If we take two houses, the Parliament and judiciary, we believe more in the judiciary. Doesn't it sounds like a dictation only when we see if judiciary is passing some decision? Parliament, on the other hand, after some days, passes a whole new bill which totally cancels out a decision of the judiciary, like the Daily Services Bill. In short answers,
Like
your
for example, if for a policy matter, and if there is a lapse in some policy and somebody goes to court, the court might have a different view. The legislature might have different view. The intent of the legislature comes from the legislation which the parliament passes. So court interprets that legislation and those words and comes to a conclusion. And parliament might think that's not the right conclusion. So it might come up with a better reformed law, right? Till the time it's in the policy domain, it's not breaches the fundamental rights or basic structure of the constitution, then Supreme Court has nothing to do with it.
Okay, so if I ask you your opinion,
Right.
is the ninth schedule
Right.
or the Article 368,
Right.
which somehow is independently providing unlimited powers to the parliament,
Right.
and the basic structure doctrine is only less practically retaining all these frameworks of constitution. What do you believe? Should we be really concerned about the these unlimited given powers of parliament, which they have eventually increased by themselves?
It might look limited for you because there are innumerable times when Parliament had passed a law, Supreme Court has struck it down. For me personally, in my opinion, till the time we are a functioning constitutional democracy, we have nothing to worry. Till the time it's not. We are not a nation which runs either on theory of law or either on sovereignty of democracy. That democracy has the supreme power. So it's not that. There are three pillars. All of them have a role to play. Until the time we have a good balance of them, it's fine.
Okay. Yes, I definitely believe that the balance is very important. The equilibrium of powers between all three pillars is very important. Let's come to democracy. We have the largest democracy in the world. After 1947, it was a really revolutionary thing that we had the largest democracy. We had a good position, good rankings as well. If we see today, recent rankings by The Economist says that we are 53rd in the whole globe in the positions of democratic rankings. Very few nations, I mean, not all the nations are democratic. Some are communist like China, or there are autocratic countries as well. In the democratic nations also, we have the largest democracy, but the rankings are so beyond, other Western nations and other nations that is 53rd. Is it really a part of concern? Or I just genuinely ask, why are the rankings declining so rapidly, and what could be the reason?
So first thing, that's not my topic. Right.
Comes under the constitution only. If the government...
no, constitution, then anything would come into a constitution. You will say, why in India health procedures are not working fine because that's against life and liberty. That's very important for healthy living in India. That's perfectly fine. But thing is, I would try to answer as good as I can, but
Sure.
That's not my subject matter, right? And I'm not defending anybody. And and I don't know what parameters were taken when you're talking about democratic ranking. And how it slid through. But
you yourself know the reality of this country. I mean, you don't have to go the outside parameters.
There are a lot of things. So we are largest democracy just because of the population we have. We have one of the largest populations in the world. So at the same time, democracy also means that everybody is empowered. In a democratic society, everyone has an equal vote, and nobody should be discriminated against others. So that is also, we are somewhere growing as a democracy, but there might be parameters we are not growing. I'm not aware of them. And at the same time, you have seen this Aadhaar and everything linked to Aadhaar. So that is also part of democratic process. Everybody is getting on an equal footing.
The democracy, which works under the constitution only, government handles it.
Right.
So democracy, constitution, both of these things are for people only, for the people, by the people.
Yeah, that's how it is in India.
Yeah. I mean, theoretically, yes, this is in India. We cannot.
But tell me where it's not. Everybody has a right to speak. They have freedom of
correct.
expression,
I'm not questioning
their
over
freedom
that.
to vote, to choose which political party they want to vote for. That all is there.
Okay, for now, I will not question over there because the fourth pillar, that is media, is itself not working very well for now. But okay,
Yeah, I agree to it. Media is not.
yeah, now it came to me. You're saying so.
Yeah,
Okay.
I see same news on every news channels
So
and
what's my
same
question
tone.
would be that yes, it is definitely very important to keep an equilibrium of powers between all the houses, all the pillars of constitution. What I personally believe would have been better that our judicial system also had the power of activism to amend some bills, some laws, like the Western nation, the America had. Even we,
So that's the difference. No, America runs on theory of law. Britain runs on democratic sovereignty. We are a mixture of everything best in the world as per the constitution. So we have given enough power to each other to keep it in check if one authority does not oversteps on other authority shoes. And that's the beauty of Indian constitution.
overstepping, definitely, I understand this question. We are only inspired by these governments only, like the American government for the fundamental rights, some French or Italian, the European government for the liberty and everything. If America is really, somewhere doing, if we believe they are doing well in terms of handling the government and the controlling of law, and they are providing enough powers to the judiciary, because judicial system is only system which allows you to appeal, which you have the right to appeal against any bill in judiciary, in the Supreme Court, every court, but not in the Parliament. So, do you think the Supreme, the apex court, should have had the power to amend, to curtail, or to introduce itself uh, some new bill which is really, required in a nation?
So, bill, I think, so is right of the parliament to be introduced. New law, as you say, new law. So, America runs on a different model, and look at the beauty when you're talking if you're comparing Supreme Court of India with Supreme Court of America. Supreme Court of America functions around for 42 days in a year, with one hearing in morning, one hearing in the evening, almost 84 hearings in a year. We do maybe more than 1,000 cases in a day. I don't know the exact number because each court might have around 80 to 100 cases in a day, or maybe 60 to 100 cases in a day. So if you see like that, our court is people's court. It's functioning well with some delays because of the infrastructural issues and a lot of burden on it. But if you want to, I would not like to question the intelligence of framers of the Constitution. And I would think it will be too much of a judicial activism to take some power out of the parliament and give it to judiciary, or make it more unbalanced that anybody could do anything they want.
Okay. So last question, a little personal. You have been in this profession from quite a while. So have your own perspective changed anyway before and after getting into this profession of law?
A lot has changed. I also used
What do
to
you
feel-
think about judiciary now?
I also used to feel that why in the hell cases take so much of time in India, and which is being portrayed thankfully by media, that because of judiciary things are delayed. And I think so the procedure we have is optimized, is really nice procedure, which we have adopted. It's just that because of infrastructural issues, because of our investigating agencies also creating delays, not completing their work on time, because of, as a society, we are not very keen on finishing things on time. There's a delay, but as a system, I don't think so. There are a lot of flaws.
We see the judiciary, it is the most prominent institution of India. Why do we see it as being victimized at a point? I don't know if it is right or not, but Is it because it is at the forefront of the the constitution, or is it because the other institutions, the parliament, the administration is trying to, how do I say, subjugate, dominate, or trying to weaken?
I have
judiciary?
other view on it. So the beauty or the power of judiciary comes from the publicity out of it. So that is why whenever a judgment has to be pronounced, it's done in a open court, and court have to cite rationales for what they are doing, right? So what happens? The checks and balances of judiciary not only comes from laws, from parliament, from constitution, but it also comes from the society itself. So when you put it out there in open, you are also answerable to the society. So because it has to be done publicly and you're accountable to the society, you generate publicity, and which is part of the job. What should be looked into when you're going to make a decision are legal principles, our constitution, and tenets of the law, and that's the role of the judiciary. So I think so that what you're talking about, victimization, media, that's for media to look into, and I think so that's media's job.
Okay, cool. Coming towards the end of this discussion, let's talk about something that is currently flowing in the market. So, a hot topic that is going into the debates, discussions today, nowadays is UCC, that is Uniform Civil Code. This is not something new. This is going from the decades only, but now it is more into discussion. Is it going well with the framework of Indian Constitution?
So I think so that debate was always on, even when framers of the constitutions were working on producing the document which we have right now. They had it in mind. There were constitutional debates on it. And that is why they included it in directive principles. And they envisioned at some point, we will have UCC. And if you look at the logic of it, we have right to equality. We have prohibition under against discrimination based on caste or religion. And at the same time, we have different personal laws. So different personal laws based on religion, which put even somebody from different gender at an advantage or a disadvantage. So looking at other fundamental rights, and also looking at Directive Principle Article 44, it is must, because even after decades of independence, we cannot have one personal law governing each other. It's I think that's certainly one of the negatives of a modern state. In all other states, on all other modern states, religion is a personal thing. But when it comes to personal laws, equality takes over, right? So India is one anomaly compared to all other nations, that we are still carrying on with different personal laws in one nation. Even in other nations which are driven by a religious ideology, you will have one law based on that religion. So in a constitutional democracy, you should have one law for everybody. And there would be people who would not be happy with it from all fringes. And it's part of evolution. We should accommodate them. We should listen to them. And we should come to a conclusion that all of us are on equal footing. Nobody, male, female, from different sects, from different religion, is at disadvantage.
But there already have been attempts of implying this Uniform Civil Code before also. Like when we saw it in the Rajiv Gandhi's era, the main issue which came from the Muslim communities, and that the concept of alimony that is in the Uniform Civil Code, that is not going well with the Muslim Marriage Act and the rituals that they follow in their religion. That's why they were really not happy with this UCC coming
So
up.
people grow. Like, for example, there was no concept of divorce in Hindu law, but that has been evolved with. So it is duty of the legislators, it's duty of Supreme Court, it's duty of all the organs to make sure we are a functioning, rational, modern democracy. We value our preamble, we value our fundamental rights in Constitution, and and all the good things take time to happen. And I think so. We cannot delay it much further. The sooner it is, the better it will be.
If we see in current times also, there is a certain sort of, kind of fear in people's mind, especially in some tribal people, that their rights can be, somewhere curtailed, and they'll be again sidelined by the government after the UCC.
Firstly, I don't agree to word again, because since independence, we have been preserving rights of different tribes. And what I heard last from the government on UCC, that rights of tribals will not be infringed upon. The safeguards guaranteed to them under the Constitution will be there. It's only the different personal religious laws of different religion should be merged into one. A common code will come for them. We have to identify as citizens. We have to identify as equal Indians, right? So we cannot have different laws based on religion, because it creates different identities even for individuals or different genders within that religion, also for different communities. So, and it's high time that we should evolve. And all the communities have, over a period of time, evolved. So before, if you go into the history of these laws, every sect used to have their own law of all religions. Then they evolved to one law for one religion. Now it's time we should evolve for one law for all citizens. And when you're looking at different religions, so it's not looked at in the view of minority or majority. Hindu personal law, Christian personal law, Parsis personal law, Muslim personal law. So there's no majority or minority here. It's just that different religions have different laws. And as a nation, as a modern state, as a nation governed by principles announced in Constitution and Preamble, so guarantees the fundamental rights. So we should come up with same personal law. Why should religious identity be bigger than individual identity or a national identity?
Still, the drafting of UCC is yet to come, so we cannot comment if they are really providing any special.
So we'll cross the bridge when it comes. So that is a different aspect. But as a concept, everybody should be agreeable to it. And we cannot live in our, I would say, our jungle Raj anymore, where everybody would want to. For example, if somebody starts a new religion, which has like a 5% of our population, would they have a separate law for that religion?
Because I think we should end this debate. The discussion here only. It was really fun to argue with you about the topics which are really less touched upon the internet, and it was really important to put some knowledge, put some light on these topics for the public. And it was really great. It was really interesting, and I have got many concerns clarified in my mind as well. So thank you very much for joining me in this podcast, and also to let me shoot in your office. So it was
Thank you so much for grilling me. It will make me also ensure that for next time you're here, I'll revise it.
I'm sure your questions
I'll read much more. And thank you for being such a nice host in the conversation.
Thank you very much.
Thank you.
It was great.